Right, we'll start today. Actually, that I'm going to have a lesson. This is a revision lesson because I believe that this topic may have been uh, done already by the other lecture. However, so I will cover two topics today with you as a revision class. So what we are going to discuss today, the first lesson is special debt recovery laws. So so we'll see uh, the debt recovery mechanism and debt recovery laws, and special debt recovery laws apply to the banks. For your exam, that in past papers also, there's a definitely there will be a question, and there were one or more questions that all papers, last past papers, if you go through, you can see from this area. Especially those questions in the second part of the paper, that is essay type questions. So therefore you can, and the other thing is this topic, if you study and properly, that you can easily get full marks. So one of the question that you can answer well and score well. So therefore I always recommend to my students to study this part, because you can get easily, you can get full marks. Okay, so we'll see what are the laws applicable, or what are the debt recovery procedures in banks and also in other financial institutions. Right. First of all, we'll see as a bank, when we are lending money, there are two types of facilities, bank facilities. So one is that the facility is secured by a collateral. So the other one is unsecured facilities, or facilities not secured by any collateral. Sometimes we use the word clean facilities. So without any collateral, any securities. Why we take a security? When we put that question, why actually we need a security or collateral? What is the idea behind that? When we are granting a loan or granting a facility, we evaluate the customer. The bank evaluate the customer. When we say we are evaluating the customer, what we are evaluating? We are evaluating the repayment capacity of the customer, whether he can repay the loan or the facility with interest as agreed. So we say we grant a loan for 5 years, 60 months, say 5 million loan, and the customer agreed to pay with 18% interest. Just an example. So when before we grant the facility, we see the possibility, the capacity of repayment of the customer. If we see there's a risk involved in this, when we are after analyzing, if we realize there is a risk, the repayment capacity is low, or you have a doubt, then what to mitigate that risk, what we do is we take a collateral, a security. So then the idea behind this taking a collateral is, in case if customer default the payment, we can take the collateral, we can liquid the collateral, and we can get the facility settled. So that is the idea behind. But when we say we can take collaterals, don't think that taking collateral is the number one when you are lending. It is not number one. Actually, it is number two. The number one point is properly evaluate the customer. The repayment capacity of the customer is number one. So then, if there is a lack, or if there is a risk in that capacity, then you go for the collateral. So I have experience in sometimes when banks and the financial institution, when they are lending, they believe or they think when you get a collateral that you are secured, fully secured, then you can easily recover the facility if they default. But when we study the law, you will see it is not that easy to recover a loan by liquidating the collateral unless it is cashback loan. So examples for secured facilities, we can give some examples. Facilities secured by guarantee bond, personal guarantee bonds or corporate guarantees that we can take, we take as a collateral when we are lending. That's one. The other one is FDs. So you know that when a customer has a fixed deposit in your bank, then you can lend against the fixed deposit. Keep that fixed deposit as a lien, and you can lend. So then in case of default, what you have to do is you have to uplift the fixed deposit and can settle the loan. Then the other famous collateral is mortgages. Mortgages, we take mortgages on movable properties and immovable properties both. Then we have pledge loans. Pledge loans that we normally, or basically we use when we are importing goods, or even we can give loans, pledge loans to the local customers also. We take the goods, we pledge as a security, and pledge the goods, and we'll lend against the pledged goods. The goods are the security of pledge loan. The leasing is another facility that the banks and financial leasing institutions that they facilitate for the customers. In a leasing facility, the vehicle or the equipment or the machine that we lease is the collateral. So we can repossess the vehicle or the machine or the equipment if customer default. Then the other one is pawn or pawn loans, that you know the gold articles that you take as a and you can lend against those gold articles. So some of the secured facilities are there that I have given here. Then unsecured facilities, example, casual overdraft. Casual overdraft means that you pay a check of a customer without any prior agreement, a written agreement or collateral. So depending on the customer's previous transaction, the manager or high authority of the bank can take a decision to pay the check by overdrawing the customer's account. So legally, it is acceptable. The casual overdraft being accepted by courts, then the customer has to pay the outstanding of the current account together with interest when the bank demands. So that is casual overdraft. Then a temporary overdraft is another facility type that we use in banks, when a current account holder can request for a overdraft facility for a temporary period. So then we mark a limit. If the limit is low and the period is short, that we don't take a collateral most of the time. We grant a temporary overdraft if the amount is low and the tenor is short without any collateral. Of course, if the tenor is long and the amount or the limit is high, then we get collaterals. So that's temporary overdraft. Then short-term loans, we know the personal loans or other type short-term loans like 1 year or 6 month period term loans, we consider as short-term loans. Again, if the tenor is short and the amount is the granting amount is low, then without any collateral, that we grant short-term loans to the customers. Again, if the loan amount is high, and the tenor is long, then we ask for collaterals like personal guarantees or mortgages likewise. Then the credit card, of course, is another example for unsecured facility. So we give a card to the customer, we issue a card, the customer can use the card and purchase services and goods and services from merchants on credit basis. So there's no security in a credit card facility. Customer has to settle the credit card account with the interest. There's a written agreement, but there's no collateral in credit card. So these are some of the examples that I can give for unsecured facilities. So then we go to the next slide. Now it's about a recovery of debt. Now that is when we lend a facility, a loan or credit card or whatever, the customer agreed to pay back the loan or the facility and interest. So sometimes that you may have experienced, all the customers won't pay. So if we grant 100 loans, if we grant 100 loans, some percentage of those loans go bad. We call it NPL ratio, right? So if a NPL ratio, non-performing loan ratio, is high, that means that that your credit portfolio is in danger. So you have to maintain the NPL ratio very low as much possible. So that is the idea. So then how do you keep this NPL ratio low or non-performing loan ratio low? So for that, you should have a good debt recovery mechanism in every institution, banks, financial institution, or whatever it is, that they should have a good debt recovery mechanism. So when we say the debt recovery mechanism in an institution or bank or financial institution, there are two types of debt recovery mechanism. One is pre-litigation debt recovery mechanism, and the other one is litigation mechanism. So before we go, litigation means that you go into the courts and file action. So that is called litigation mechanism. So litigation mechanism we start as the last resource, not as the first resource. So I will explain why. The litigation, if you have experience, litigation in Sri Lanka is one, it is costly. The other one, it is time consuming. So it's lengthy process to get a judgment in a normal action or normal money recovery action. It takes about 3 to 4 years. So that means that if you go today and file action against a customer, so your final judgment or the result you will get after 3-4 years. So when you looked at that, you see it is not very efficient debt recovery method, because for example, we say you grant a loan, a short-term loan for 2 years. So that is 24 months. So customer defaulted the loan after 6 months. So then we say you straight away start litigation process. So after 6 months, you start the litigation, and then you go courts and fight, and you get the judgment at last after 3 or 4 years. So then now you see your loan, the customer's loan, he has to pay within 2 years' time. So then you file action and you wait another 4 years to get the judgment. So then at that time, during this period, the money that you lent, you can't recover. So that is a cost to the bank or to the institution, because you know that you have lent the depositors money. So for the depositors, that the bank has to pay interest. The one side that you have lent money, you can't recover, but you have to pay depositors. So then the litigation process in Sri Lanka is not, when we consider in the time factor and the cost involved, it's not a very speedy or very efficient mechanism. So therefore, we should have a better, effective pre-litigation debt recovery mechanism. That means before you go into the courts, that you should have a mechanism. Visit the customer, convince him to pay, give him a reschedulement or easy payment system, and encourage him to pay. Likewise, that you should have a mechanism. So some banks, they have outsourced the recovery process, pre-litigation process. So likewise, you should have a good pre-litigation mechanism. So if a pre-litigation mechanism also fails, then you go into the litigation process. So here for our exam and for this project program rather, that we have to study the laws related to debt recoveries. So first one, the first process, only the procedure that we are going to study is a recovery of debt through courts, a regular procedure under debt recovery through courts, right? We'll say what is, we'll try to understand what is this procedure. I said this is a regular procedure. So regular procedure, again, remember that you have to follow all the steps laid down in law, and it is lengthy process, time consuming, right? First, when a default is made by a customer, the first step that the bank has to take is send a letter of demand. Sending of letter of demand. The bank has to send a letter of demand. Bank or the institution has to send a letter of demand to the customer, the borrower. So letter of demands are sent by lawyers. So you, the bank or the institution, give instructions to the lawyer. Then the lawyer prepared the letter of demand on the instructions of the company or the bank. Send the letter of demand to the borrower. If there are guarantors, that we have to demand money from the borrower and as well as from the guarantors. If there is a mortgagor or rather mortgagee, then we have to demand money from the borrower and also from the mortgagor. So likewise, we send letter of demand to the borrower and as well as the sureties. That's number one. It's normally, when you send the letter of demand, you give 14 days to the customer, to the borrower, or to the guarantors to pay the total dues to the bank. So 14 days is not a must, but you normally give reasonable time them to pay. So reasonable time in law, we as a practice, we consider as 14 days. So after 14 days, that means after the time lapse, if customer doesn't pay within 14 days, then the bank or the company has a cause of action against the customer to file a case. So then the next step is, under the regular procedure, the bank or the company has to file a legal action in courts. When you say filing of legal action, you file a document called plaint. In Sinhala, we use the word paminilla. So we filed a plaint in courts. Together with the plaint, that we have to file the documents. Especially, for example, if we take a loan, then you know the loans, when you are granting a loan, that you sign a loan agreement. First you give offer letter, the customer accept the offer letter, then after that you sign documents. So one of those documents is the loan agreement. So that agreement that you have to annex to the plaint. So that in that agreement, both parties, that is the bank and the borrower, agree to certain terms. Right? What is the tenor of the loan? What is the installment, monthly installment? How many installment the customer has to pay? The interest rate, whether it's a flat rate, whether it's a fluctuating rate. So likewise, that the conditions of the loan applicable conditions are mentioned in the loan agreement, so that you have to annex to the plate. Then the other documents like account statements and the letter of demand, those documents also you have to annex to the plate. Then after filing the action, that means after filing the plaint in courts, court issue summons to the defendant. Defendant means the borrower. Issue summons. Summons in Sinhala we call sitasi, right? Summons through registered post and also through the fiscal. Fiscal is an officer who attached to the courthouses. Their job is to deliver summons and other notices of the courts to the parties of a case. So second step, summons served to the defendant. Once the summons are served to the defendant, that is the borrower and the guarantors, they come and they have to file their answer to the plaint that we file. So third step, the borrower and the guarantors, they have to file their answers in courts. Now, once they file answer, now there is a plaint and there is an answer. Then the matter will be fixed for a trial, because judge has to decide whose story is correct and who should get a relief through this court process. So then the matter will fix for trial. At the trial, normally in the regular procedure, the plaintiff has to start the case. Plaintiff means in a loan recovery, debt recovery matter, the lender, that is the bank or the lending institution, they are the plaintiff. They have to start the case. Start the case at the trial. When you say start the case, means that the plaintiff representatives, that is office bearers, they have to give evidence in courts and they have to mark their documents at the trial. So after plaintiff case is over, that means after the evidence of the plaintiff been taken, then the next step is the defendant's turn. That defendant can give evidence or can bring another person or someone to give evidence on behalf of him, and also can mark documents. So after the trial, after getting evidence of the plaintiff, that is the lender, and also the defendant, that is the borrower, and also the guarantors, then the matter will be fixed for the judgment. So based on the evidence, based on the documents that marked by the both parties, and based on the law principle applicable, after considering all these things, the judgment, the judge will pronounce the judgment. Judge will give the judgment. So if the judgment is in favor of the plaintiff, the bank or the company, the next step is execution of decree. Execution of decree means once a judgment is given in favor of the bank, now bank has to recover the money. So judgment means the judge pronounced that the bank is entitled to recover recover so much. We say rupees this much and interest from the defendant or defendants. So that is a statement, or judgment is a statement. Then how do you get the money? The plaintiff or the bank, how do you get the money from the defendant? So that process is called execution of decree. So execution of decree means the fiscal officer of the courts, based on the judgment, will go and seize the properties of the defendants, the borrower and the guarantors. So there are some goods or articles that the fiscal can't seize. For example, the clothes, the bed, the residential property, and the equipment used for livelihood of the the borrower or the guarantors, those things cannot seize. The other things, household items, money, salary, all these things can be seized by the fiscal. Now, after seizing the properties of the borrower and the guarantors, then the court can or should auction the properties, seize properties. So after auctioning the property, from the proceed of the auction, the plaintiff, the bank or the company can recover their money and also the expenses. So that is the process or procedure under court procedure, regular procedure. These are the main steps that you have to follow. So if you have any questions from this process, or if you are not clear, that you can answer, you can ask the question, so I can clarify you if you need any clarification. Are you okay with the regular process? Because now thereafter we are going to discuss the special laws. So you should have a clear idea of the regular process to study the other processes. Otherwise, that it will be difficult. So you have any questions from here? Okay, if you don't have any questions, that means if you clearly understood the process, the regular procedure, then I will go to the other processes. That is debt recovery special laws. We are going to study debt recovery special laws. Remember, for your exam, you have to study 2 special debt recovery laws. Those are, number 1, Debt Recovery Special Act, Debt Recovery Special Provisions Act number 2 of 1990. Number 1, Debt Recovery Special Provisions Act number 2 of 1990. The other one is Debt Recovery by Banks Special Provisions Act number 4 of 1990. Those are the 2 acts that you have to study for your exam. 2 of 1990, Debt Recovery Special Provisions Act, and Act number 4 of 1990, Recovery of Debt by Banks Special Provisions Act. So those 2 you have to remember. We'll take number 1, the first special law that we have to study for the exam. That is Act number 2 of 1990, Debt Recovery Special Provisions Act. But you have to remember the number, year, and the name of the act. Act number 2, year 1990. The name of the act is Debt Recovery within bracket Special Provisions Act. When we see this the word Special Provisions Act, it means this is a special procedure introduced by this act. That means there is a procedure. Apart from that procedure, established procedure, that the legislature introduced a special procedure for a particular purpose. Now here, this you can see, this debt recovery process. For the debt recovery process, the legislature has introduced a special law. So previously, before this, we studied this recovery of debt, regular process. So this is the established debt recovery procedure. This is established in Civil Procedure Code. This is the mechanism that we normally use in courts to recover loans or debts. So as I told you, since this is a regular process, it takes time, and get a final judgment or final result, it takes about 3 to 4 years. So So the banks and the financial institutions can't wait that long to recover their loans. So it's not healthy for the banks and financial institutions. So therefore, there was a discussion, there was a concern that they should have a speedy mechanism to recover the debts. So that's why this special law were introduced. So in this era, there was a discussion to introduce new laws.
Excuse me, sir.
Yes.
So is there any probability that the bank could like threat him and get the, recover the debt?
I couldn't hear the latter part of your question. Can you repeat the question?
So is there any probability that the bank could threat and get the debt?
Bank could threat.
Yeah.
Okay. Okay. Good question. I said the bank should have a bank and the financial institution should have a two mechanism, rather debt recovery mechanism. One is the litigation process, that is in the court process. The other one, pre-litigation process. The question is whether we can threat the customer and get money. So the simple answer is no. You can't threat, because threatening is not acceptable, and the customer can lodge a police complaint if you threat to his that is a criminal offense. Then, right? Then you will be in trouble. So you have to handle the customer in a diplomatic way. So that's why I told you that you can approach the customer, you can discuss with the customer, you can convince the customer to pay. You can say, you can threat like this. You can say that if you don't pay, that we will sue you. We will file action against you. Then that you will suffer, because you have to pay money. You have money. You have to pay lawyers. You have to go through the procedure. So your time will be wasted. Likewise, you can convince him, but you can't threat him. You can't say that, okay, if you don't pay, that I'm going to put you into the Facebook, and that I will tell all of your friends that you have defaulted. Likewise, you can't threat. So threatening is not an acceptable or accepted mechanism in debt recovery. So I believe that your question is answered. So we have experience especially when we outsource the debt recovery process. These outsourcing companies, their agents, they go and they visit customers, they treat the customers, they visit the neighbors, they go to the working places, office of the customer, and inform the other co-workers. Likewise, a lot of unethical and unlawful things has happened and happening when we are outsourcing. So that is not acceptable, and the customer can sue the bank and ask damages, and also same time the customer can lodge a complaint against the people who have threatened him under criminal law. So that is the danger. So I believe that your question is answered.
Yeah, sir. Thank you. Sir, can a leasing company do that?
Okay, another good question. Whether the leasing company can do that? Okay, under the Leasing Act, Finance Leasing Act, it's a different act. When the lease is terminated, when the lease is defaulted, the bank or the leasing company can terminate the lease agreement. After a lease agreement is terminated, the customer or the lessee has to hand over the vehicle or the instrument or the machine to the company. So after terminating the lease agreement, the lease property, vehicle, machine, or the equipment is not a property of the customer. This you have to very carefully or very thoroughly understand. When we talk about the leasing facility, the equipment or the vehicle is a property of the company. It is not the property of the customer. The title of the vehicle or the property is with the bank. The ownership is with the bank. The lessee is only a registered owner. He has no actual ownership to the item, lease item. So once the lease agreement is terminated, there is a clause in the agreement say the lessee, the customer has to hand over the vehicle or the equipment or the machine to the company. And as per the Finance Leasing Act, if it is not handed over to the company can repossess the vehicle or the equipment. So when you are repossessing, first you have to, there are two mechanisms. One is that you can go to police and lodge a complaint, and with the support of the police, that you can go to the place where the vehicle or the machine is kept, and you can take the possession and bring the vehicle or the equipment or the machine to your yard or your place. So that is one mechanism. The other one is if the customer is resisting and not handing over the vehicle or the goods to the lessee, under the Leasing Act, Finance Leasing Act, there is a provision that you can file action in courts and you can get the possession of the equipment through courts, through the fiscal. So other than that, again, threatening is not acceptable or is not given permission to the financial institution and banks in a leasing facilities also. But again, when we talk about the repossession, it is again outsourced, right? Most of the time we give that part of the lease outsourced to the outsourced company. We call them seizures, right? They go and they do certain things which is not acceptable, unethical. Again, so therefore, threatening in leasing facilities was also not allowed. However, repossession is allowed. Repossession is allowed. So you have a right to get the repossession. So are you clear?
So under the Parate condition, what will happen?
Under the Parate
Conditions?
So okay, Parate that we are going to discuss after this. So then you can answer the sorry, I can answer your question after that. So can you please answer your question after I discuss Parate process?
Yeah. Okay. So thank you.
Okay, right. So then we'll go to this Debt Recovery Special Provisions Act. So I said this Special Provisions Act has been introduced a special procedure to recover debts. So what is the speciality of this act? This act has introduced a very short version of a litigation process. So as I told you before, previously I told you the regular procedure is a lengthy process. It takes about 3 to 4 or 5 years to get a judgment. So instead of that, instead of following the regular procedure in courts, this act has allowed the banks and the institutions to follow a summary procedure, which is shortened version of the regular procedure. So under this process, if you file action under 2 of 1990, within a year, within 1 year or less, that you can get the final result. So compared to the regular procedure, which takes about 4 to 5 years or 3 to 5 years, get a final order, final result, debt recovery process under 2 of 1990 is a speedy process. It takes only 1 year to get the final result. So again, it's a court process. There are steps that you have to follow. So those steps that you have to study now for your exam, right? And your knowledge also, right? For your knowledge, enhance your knowledge also, right? Okay. So what is the purpose of introducing this act? The purpose is to provide a speedy procedure to recover of debt through court process. So I have highlighted the process in red. I have highlighted that part in red, through court. So why I have highlighted this part is, now next we are going to study 4 of 1990. It's another process to recover loans, but the difference here is 2 of 1990 is a court process. 4 of 1990 is not a court process, right? In your exam, sometimes they can answer questions to compare these two debt recovery processes. That is number 2 of 1990 and 4 of 1990. Right? So therefore, understanding this process is very important. If you have to compare, that you have to have a good idea, a very comprehensive idea of both 2 of 1990 and also 4 of 1990. So one difference is 2 of 1990 is a court process, 4 of 1990 is not a court process. Right. So then under 2 of 1990, what is the procedure for what type of institutions it applicable? Or the other question, if I put the question in another way, can everyone file action under 2 of 1990 if a loan or debt is defaulted? So question answer is no. It is applicable only to certain category of lenders. So it's applicable to lending institutions. So lending institution has been mentioned in the act. What are the lending institution applicable? All the commercial banks are coming under this. So every commercial bank can file action under Debt Recovery Act number 4 of 1990. Sorry, rather 2 of 1990. Then SMIB, NDB, NSB, DFCC, and registered finance companies also coming under this category under lending institutions. So therefore, they also can file action under Debt Recovery 2 of 1990. So what is the procedure applicable in this court process? The procedure is summary procedure. Summary procedure, not the regular procedure, right? The previous one we said regular procedure. This one is a summary procedure. Summary in Sinhala we call lagu, right? Summary means it's a shortened version, right? Now, for example, we say now you take a novel or you take an article. Sometimes you have the article goes to, we say 300 pages, but you have a summary. You have a summary of the article. So which is 1 page or half a page, right? It has summarized all the important parts of the article and it has shortened the article. So once you read the summary, you can get an idea of the article. Likewise here, what has happened, what they have done, they have summarized the regular procedure and shortened the process, the time taken to get a final version. So that's what has happened here. So the procedure applicable, the procedure applied in courts is summary procedure. That's number 3. Then there's another important point. When you are filing action under 2 of 1990, the debt or the claim has to be over 150,000. If the loan amount or rather outstanding amount is below 150,000, then you can't file action under 2 of 1990. For example, we say now we have given a personal loan 50,000 and he has defaulted. The outstanding is, we say 55,000. 50,000 capital outstanding and interest 5,000. So it is below 150,000. So then you can't file action under 2 of 1990. So then you have to follow the regular process. So for your exam, that they can give a case study and they can ask the question. They can ask you to choose the correct procedure or the most suitable procedure to recover the loan. So then you have to see whether you have to apply a regular procedure, or whether you can apply 2 of 1990 procedure, or whether you can apply 4 of 1990 procedure. So out of these three, what is the most suitable procedure that you have to adapt in this case? Likewise, you have to think little louder and you have to choose the correct mechanism. So you can't choose the correct mechanism or correct procedure unless you have studied all these three procedures, right? So another limitation is under 2 of 1990, the loan amount has to be over 150,000. If it is below that, you can't file 2 of 1990 under the 2 of 1990 procedure. Then you have to file action under 4 of 1990, rather a regular procedure. Right. Then the facility must be granted on an instrument or on a written agreement. That's the other important point. The facility must be granted on an instrument. Instrument means a financial instrument like check, a promissory note. Likewise, some instrument must be there. Written instrument must be there. Or it has to be there has to be a written agreement. Now, when you see this limitation, you see for a casual overdraft that you can't file debt recovery act under 2 of 1990, because casual overdraft you don't have a written agreement and you don't have any instrument. There's no promissory note, right? Nothing. Just after analyzing the customer's previous transaction, the relationship with the bank, that the bank manager or the higher authority decide to pay his checks by overdrawing the account. So that is called casual overdraft. So there's no agreement, no written agreement. Then there's no written instrument like promissory note. So in a case like that, a casual overdraft, what is the most suitable procedure? It is not 2 of 1990. You have to go you have to follow the regular procedure. Though it is very slow, there's no other option because there is no written agreement. So these are the limitations that you have to remember. This applies only to the institutions, lending institutions, not to individuals, not to partnerships, not to others. It's applicable only to the lending institutions. So lending institutions are commercial banks that I have given here. So those are the institutions that they can file action under this debt recovery. Then the procedure applicable here is the summary procedure. Then the amount, the other limitation, the loan amount or the outstanding amount has to be 150,000 or above. 150,000, right, or above. Then the next one, there has to be a instrument or there has to be a written agreement. If these conditions are fulfilled, then we can choose the procedure under 2 of 1990. Right. Now we'll go to the procedure. Main steps of this procedure. Right. When a customer default a facility, and if the facility is granted on a written agreement, and if the loan amount is over 150,000, or rather the outstanding amount is 150,000, and if that facility has been granted by a bank or lending institution, then we can file a debt recovery action under 2 of 1990 in courts. So what is the first step that we have to follow in debt recovery action? So debt recovery action also, the first step is we have to send a letter of demand. We have to demand the money. We demand the outstanding from the borrower and also from the guarantors if there are guarantors. So first step is sending of letter of demand. So after sending the letter of demand by letter, we give him a 14 days to settle. So if he doesn't settle the OD, or rather the loan or the outstanding, then what we do, the second step, we file action in courts. We file action. So now just think about the regular procedure. Under the regular procedure also, the second step after sending the letter of demand, we file action. We file action means, I told you, filing action means that we file a plaint. We file a plaint. So here also we are filing a plaint, but there is a difference. There are other documents, additional documents that you have to file together with the plaint in a case of 2 of 1990. So what are those additional documents? Now together with the plaint, that we have to annex, or we have to attach the written agreement or the instrument. Remember that I told you, if the loan is granted on an instrument or on a written agreement, only that we can file action under 2 of 1990. So here now, with the plaint, when we are filing, we have to annex the written agreement or the instrument. Instrument means the promissory note or check or whatever the instrument that you have in writing, that you have to annex to the plaint. And there's another important document that you have to annex to the plaint under 2 of 1990. That is an affidavit from a principal officer of the financial institution or lending institution. So that a principal officer has to give an affidavit to that effect and has to annex to the plaint. That's another document. And also other written evidence which help to prove your case. That all that you have to annex to the plaint. So what are the documents now we have to annex to the plaint? Number one, you have to file the plaint together with the written agreement or the promise or the instrument that you have to annex to the plaint, and also that you have to annex an affidavit from a principal officer of the company, and all other evidence, written evidence that you have available with you to prove your case. All that you have to provide with the plaint. So number two, that filing of plaint. So now you see, together with the plaint, we are filing an affidavit, and also we are filing all the evidence that available you are provide with the plaint. Now under the regular process, you give evidence or written or verbal evidence at the trial stage. But here the difference is at the first stage, at the beginning, when you are filing, at that point we give all the documents and all the written agreements and also written evidence with the plaint. So that's number one. After filing these documents, then court gives a date to support the matter in courts. So now you file the action and court gives a day to the plaintiff, that is lending institution, to come to courts and support their case. Supporting means that the lawyer who appears for the lending institution has to convince the judge by his oral submissions, and also based on the documents that you have annexed to the plaint, based on the affidavit that you annex to the plaint, and other evidence that you have annexed to the plate, that you have to, your lawyer has to convince the judge that you have a case against the borrower, and the borrower is obliged to pay whatever the amount that you claim. So that you have to, your lawyer has to convince the judge. That is called supporting the case in courts. So supporting the case in courts, that is a ex parte support. That means the defendant or the borrower or the guarantors are not in present in courts, right? It's only you and your lawyer explain the case to the judge and convince him that you are entitled to the money that you have claimed in your claim. So that is number two or the number three. Then the next one, after supporting the matter in courts, if judge is satisfied that the amount mentioned in your plaint is duly owed to you from the borrowers, and whether if there are sureties from them, then judge will give a temporary order, temporary judgment. The temporary judgment, it has a special name. It is called NISI, NISI. That's a temporary order, temporary judgment, which is called decree order NISI. Order NISI. So once the order NISI is issued, then the order NISI, or rather, it will be converted to a decree, and the decree NISI will be served to the defendant, to the borrower. So that is the first time that the defendant get to know that that the bank or the lending institution has filed action against him, and by that time the court has issued a temporary judgment against him. Now you see, in the regular process, to get the judgment, it takes about 3 to 4 years. But here, after you filing the case, you get a chance to support the matter in courts, and after supporting the matter, if the judge is satisfied, then judge will issue a temporary judgment. It's a temporary judgment, but within very short period, within few weeks, that you can get a judgment. Though it is not a final judgment, it's called decree. It's called judgment NISI or a NISI, temporary judgment, but you get within a very short period. So then after that, there's no summons in this process. You don't issue summons. You straight away serve the decree NISI to the defendant. So what does it mean? So what does it carry? So it says, the decree says, the judgment, a temporary judgment has given against the borrower and also against the guarantors. But if you have any defense to intervene to the case, then you have to get permission. The defendant or the borrower has to get permission from courts. So he just can't come and file answer like in a regular action. So there's no provision to file answer. So once the decree is served to the defendant, defendant has to come to courts and file papers and has to get permission from courts to come to the case and defend the case. So now once the defendant or the borrower file papers seeking permission from courts, there are two things can happen. There are two things can happen. One is, if court is satisfied, if court is not satisfied with the documents and the papers that filed by the defendant, that is a borrower, that means court is still believe that money mentioned in the plaint is duly due to the bank or the institution. So therefore, then court will not grant permission to the defendant. So then what will happen? Permission will be refused. If court, after seeing the papers and after seeing the documents that filed by the defendant, believes that the defendant has a valid defense, or any, if judge has any doubt whether this amount mentioned in the plaint is truly due to the bank, then what has happened? What could happen? The judge can give permission to the defendant, through the borrower, to intervene to the case. So two things can happen. So grant permission, the court can grant permission, or court can refuse permission. If court grant permission, what will happen? Then the matter will fix for the defendant can file their objections. Objections means that it's like answer. Defendant can file papers and can contest the matter. Then after defendant filing the objection, the case will fix for inquiry. It's not a trial, it's an inquiry. Trial means it's a lengthy process. Inquiry is a shorter version of a trial, right? It's not a lengthy process like a trial. It's a shorter version. Within few months that you can finish the inquiry. So after having the inquiry, if court still believe that the money mentioned in the plaint is legally and duly owed to the bank or the institution, the court can then give the final judgment. That is called decree nisi will be made absolute. So decree nisi is a temporary judgment, and after it absolute by the court, it becomes a final judgment. So that is number 9, step number 9. After giving the final judgment, that means after the decree nisi made absolute, then the procedure to recover the money, that execution of decree. So then the fiscal officer, as I mentioned previously, will seize the goods and the properties and the salary of the defendants and auction the property and will recover the money of the lender. So that is the procedure under 2 of 1990. If you have any questions from here, that you can ask now. Right. Seems to be that you don't have any questions from this procedure. So therefore, then I'll go to the next one. That is,
Excuse me, sir.
yes.
So what's the difference between decree nisi and decree absolute?
Okay, right. I will explain that. What is the difference between decree nisi and decree absolute? Actually, it is not the decree nisi, it is order nisi and decree nisi. These are the different steps. Number 1, order nisi, as I told you before, is a temporary judgment. After hearing the plaintiff the case, the court gives a temporary judgment. That temporary judgment, it has a special name. It is called nisi, order nisi. So after the inquiry, if court decide the case in favor of the bank, this temporary judgment, order nisi, temporary judgment, will be converted to a final judgment. So that conversion, we called it absolute. So the court will absolute the final judgment, the decree nisi, that is called decree nisi. So order nisi is a temporary judgment, decree nisi is the final judgment. So that is the difference between the order nisi and the decree nisi. Are you clear?
Yeah, sir. Thank you.
Okay, right. Any other questions? If I clarify further, order ISI you can't after issuing a order ISI you can't go and seize the properties because it's a temporary judgment. Once the order ISI made absolute, that means once the decree ISI is issued, that is the final judgment. Then only that you can go and execute the decree and seize the properties and auction the properties. So that is the difference between decree ISI and order ISI and decree ISI. Right. Any other questions? Right. Yeah. So then I'll go to the next one, the famous one, the Parate procedure. Parate procedure. The second special law that you have to remember, you have to study and remember for your exam and also for your knowledge. This is very important. There will be definitely there will be a question from this, and also combined. It could be a combined question from this and the other one. So this is introduced. This Parate procedure was introduced by this Act number 4 of 1990. So the name of the act is Recovery of Loans by Banks Special Provisions Act number 4 of 1990. So the previous one, summary procedure, the act number was 2 of 1990 and this is 4 of 1990. You can see both special laws, debt recovery laws, have been introduced in year 1990. So 4 of 1990 is Parate process. Now if you remember this name of the act, right? So it has a lot of meanings. Now you see Recovery of Loans by Banks Special Provisions Act. So you see the word special provisions within bracket. So that means, as I told you, if you see these two words, special provisions, that means there is a laid down process, procedure, but by this act, it has introduced a new procedure. So for what? Here, to recover loans by bank. When we say by banks, this act, you see, it's apply only to the banks, not to any other institution. So Act number 4 of 1990, it's applicable only to the banks. It's not applicable to any other financial institution or individuals or no one else. So that is another difference between Act number 4 of 1990 and Act number 2 of 1990. Now, when you go to this 2 of 1990, it's applicable to the banks and also other institutions. You see, the commercial banks, special banks, financial institutions. So everyone, every lending institution can apply 2 of 1990. But when it comes to 4 of 1990, you see it's apply only to the banks, not to the financial institution. That's another difference between 4 of 1990 and 2 of 1990. Then what is the purpose? What is the purpose of having this act? So purpose mentioned in the act is an act to provide for the recovery of loans granted by banks. So again, it says it's applicable to the banks, and the purpose of the act is to recover loans given by the banks. Then the procedure, very important again, when you compare this with the 2 of 1990, you can see this procedure, the Parate procedure, is not a court procedure. It is not a court procedure. So idea behind this Parate Act, when there is a mortgage, to secure a loan, the bank can sell the property without going to courts, without filing action, without court auction. The bank itself can sell the property under auction, by an auction under Parate procedure. So therefore, no court involvement. It is not a court procedure. So that is another unique feature of this parate procedure. All right. So now we'll go to the procedure, steps, main steps of the procedure. Again, here, the idea of this act is to sell the auction the mortgage property and recover the loan. So before we start the process, as previous processes also we mentioned that we have to send the letter of demand. We have to send a letter of demand. We have to demand the money from the borrower and from the mortgagor. If mortgagor and the borrower are the same, that you have to send a letter of demand to the mortgagor borrower. That is number one. Then number two, after sending the letter of demand, if customer doesn't settle the loan outstanding and total due within 14 days, then the board of directors of the bank can pass a resolution. By passing a resolution, the board of directors can appoint an auctioneer. By passing a resolution, the board of directors, the bank can appoint an auctioneer. Appoint an auctioneer to auction the mortgage property. That is the purpose. Or there is another part, very important. The board of directors, by passing a resolution, can appoint a manager. To manage the property. So this is very important. You must understand this. By passing a resolution, the board can either they can appoint an auctioneer or they can appoint a manager. So there's a difference between these two, right? The auctioneer auctions the property. He auctions the property, he brings the money and settles the bank. The manager, if a manager is appointed, the manager has to manage the property and he has to generate income. From that money, the loan of the bank can be settled. So two different tasks, two different people. One is the auctioneer, the other one is the manager that can be appointed by passing a resolution. So that you have to remember. Then at what point we appoint an auctioneer, in what situation that we appoint the manager? That is a question. When we appoint an auctioneer, why we appoint an auctioneer? Why we appoint a manager instead of an auctioneer? So we have to think. So we say that we have obtained a collateral, a mortgage over a, we say, a factory, huge factory. Right? You say it's a garment factory. It's a mortgage to the bank. Now the loan is defaulted. Right? The bank started parate process. Now bank director board of the bank passed a resolution, going to pass a resolution. Board of directors, now they are going to pass a resolution. By passing a resolution, as per Act number 4 of 1990, two things can be done. One, the board of directors, they can appoint an auctioneer. Once the auctioneer is appointed, the auctioneer has to auction the property and get the money and bring and settle the bank. The other option is the board of directors, they can appoint a manager. The manager can generate the income and bring that money and settle the bank. There are two situations. Now court has to take a decision. Now the mortgage property is a factory. We say with employees, 3,000 employees, machineries, right, to mortgage to the bank. If board decide to auction the property, Board has to appoint an auctioneer. Auctioneer has to auction this garment factory. So the question is whether the auctioneer will be able to find a buyer to purchase this factory at the auction. So as we know, if someone wants to invest money in a garment factory, a huge factory with 3,000 employees, that no one will buy such a property at the auction, because without doing a proper analysis, proper investigation of the company, of the factory, that no one will buy just a property like that. Of course, if it is a 10 purchase bare land, so of course then at the auction the buyers will buy, because there's nothing to worry. Then if the title is okay, so there are no other encumbrances, no other problems. So therefore the auctioneer can easily auction the property and the buyer will buy. But not a company or not a factory with 3,000 employees. So it's not easy to find a buyer or bidder at the auction for a property like that. So therefore, the director board, then there is another option. The director board, by passing a resolution, can appoint a manager to run the business. So manager is then the manager is appointed by the bank. So the manager can bring the money, he can run the business and bring the money and settle the bank. So that is the other option available. So for the time being, for this exam, we are not talking about appointing a manager. So we are focusing on the other part, that is appointing an auctioneer. Appointing an auctioneer to auction the property, mortgage property, and recover. So now we'll see how and what are the steps that we have to follow to auction a property and recover money. So then board of directors pass a resolution and appoint an auctioneer. Then thereafter, the bank has to prepare a document called notice of resolution. Notice of resolution. Once the resolution is passed, the bank prepare a document called notice of resolution. So that is a notice given to the customer and to the public. The notice says that the bank has passed a resolution and the bank has appointed so and so as the auctioneer to auction this property. So that is the notice. That notice is called notice of resolution. So after notice of resolution being prepared, it has to be published in the government gazette. And also it has to be published in 3 daily newspapers in 3 languages: Sinhala, Tamil, and English. So notice of resolution has to be published in the gazette and also newspapers. So this is very important. All these steps that you should be able to explain at the exam, right? That is step number 3, or the Faraday process, step 3. Step 4, after publishing the notice of resolution, the copies of notice of resolution has to dispatch to the borrower. So you have to send the notice of resolution to the borrower. Then the 5th step, the auctioneer has to prepare a notice of sale. Notice of sale. The auctioneer prepare the notice of sale. In the notice of sale, he has to mention the date of the auction, time of the auction, the place of the auction, that you have to mention in the notice of sale. Then the auctioneer has to publish the notice of sale in the government gazette and also in, again, newspapers in 3 languages. notice of sale, publish in the Government Gazette, and publish in newspapers in 3 languages. Then there's another important part here, right? That the notice of sale has to dispatch to the borrower. Again, the notice of sale also that has to dispatch to the borrower. Number 2, it has to be posted near the property or on the property. Right? Near or on the property, it has to be posted. Next one, it is very important to do these steps before 14 days of the sale. Before the auction, before 14 days of the auction, all these steps, notice of sale has to publish in the Government Gazette, and that has to publish in the newspapers, and has to dispatch to the borrower, and has to be placed near or on the property before 14 days of the auction. So that is step number 5. Up to this point, if you have any questions, you can ask. So steps are okay, clear? Right, then I'll go to the next one. Right, next one, upset price. Now the auction is fixed, date is given, notice of sale published, it published in the Government Gazette and also in the newspapers, dispatched to the borrower and pasted near the property. The next step is the upset price. The board of directors of the bank has to decide the upset price. Upset price means the price or the value of the property, that is the minimum price of the property that the auctioneer can sell at the auction. So minimum price. If the auctioneer is selling the property to a third party or to the bidders, so he has to start the auction from the minimum price. So minimum price. So the minimum price is called upset price. It decided by the board of directors, not by the auctioneer. This is very important. So upset price will be decided by the board of directors, and the price will be communicated to the auctioneer. So the auctioneer has to start the auction from that price. So that is the minimum price that the property can be sold to a third party at the auction. Then the question is, how do you decide the upset price? The board of directors has to decide what is the upset price, or what is the minimum price that we are going to sell the property. We say that we have granted a loan and the dues are 6 million and it has been secured by a mortgage. The mortgage property, the market value of the mortgage property is 10 million. 6 million due, 10 million worth property is mortgage. Now the bank is going to auction the property. So bank is going to auction the property. What is the price, minimum price that the auctioneer can quote? That it has to be decided by the director board. So in a situation like that, the question is whether the director board, whether they can fix the upset price at 6 million, because 6 million is only amount due to the bank. Though the director board has to decide the upset price as 10 million because the market value of the property is 10 million. So how do you decide that? So there are things that you have to consider when the director board is placing or deciding the upset price. What are the things that they have to consider? Number one, the dues. How much due to the bank, that you have to consider. Then second one, what is the market price of the vehicle, rather market price of the land. Next one, what is the for sale value of the property, land. So before we go into the parate, we take a valuation report. We take a valuation report from a valuer. So if you have seen a valuation report, in the valuation report, the valuer gives two values. One is the market value, the other one is a for sale value. Market value means the real market value. If you wait for the best offer, what is the maximum price that you can get for the land? So that is called market value, market price or market value. So what is the for sale value? For sale value is if you sell in hurry without waiting for the best offer, what is the price that you can get? That is called for sale value. So three things that you have to consider. One is the dues, two, the market value, three, the for sale value. However, when you are deciding the upset price, if the market value and the for sale value is higher than the dues, the bank should not set the upset price at the amount to the amount due to the bank. So bank then has to fix the upset price to the market price of the property. Why I say this? Because as per this act, after auctioning the property, after recovering the dues to the banks, that is the loan outstanding and also the expenses, if there is excess money, that money that bank has to return to the borrower. You have to give that money to the borrower. So therefore, it is the duty of the bank to fix the upset price at the highest price that you can get. Right? So that is upset price. Then after fixing the upset price, the bank has to convey that upset price to the auctioneer. Then auctioneer, the next step, he will conduct the auction. At the auction, the auctioneer will start the bidding from the upset price. Then the bidders can bid. After considering the bid, the most successful bidder or the bidder who placed the highest bid can purchase the property at the auction. So if there is a bid, then the bidder and the auctioneer sign a document called condition of sale between the auctioneer and the buyer. Now you know at the auction that the buyer has to pay some percentage of the property value of the property. We say 25% of the property value that the buyer has to pay there, then and there. Then thereafter the balance that he get time to pay. So all these conditions are mentioned in the condition of sale. So the condition of sale is signed between the auctioneer and the buyer. So after the condition of sale is signed, then the buyer has to pay the balance money as per the conditions mentioned in the condition of sale. So if we pay all the dues or the money as per the condition of sale, then the bank issue a document called certificate of sale. Certificate of sale is like a deed. It's a deed actually. So by this certificate of sale, the ownership of the property will be transferred to the buyer. So he gets the title to the property. So when after issuing the certificate of sale, from the money that the bank received from the buyer for the land, the outstanding of the loan can be settled. Then thereafter, if there are any excess money, that money has to be returned to the borrower. So those are the steps that you have to follow under Parate process. Any clarification or any question that you have that you can ask now regarding Parate process or steps of the Parate process? If you have any question that you can ask. Okay, it seems to be you don't have any questions. Then I will go to the next one. Right. Right. Next one, restrictions on Parate process. Restrictions on Parate process. Now, I said the Parate process has been introduced to auction the mortgage property under Parate process. And the Parate Act 4 of 1990 only applicable to the banks. It is not applicable to the financial institution. So those are some of the restrictions. It's only applicable to the banks, others can't follow. Now, apart from that, there are restrictions made to the Parate process, right? So, number one is granted loan amount. Now, you see, in 2011, two amendments was introduced to the Act number 4 of 1990. In 2011, Act number 4 of 1990 amended twice. So those amendments are called number 1 of 2011 and number 19 of 2011. So what happened here, by this amendment, the legislature put a limitation or restriction on Parate process. Now the initial, as per the previous act, initial act, there was no restriction like this. If the property, if the loan is granted by a bank and if it is secured by a mortgage, if the loan is defaulted, then the bank can go Parate. But after introducing this amendment, 2011, number 1 and 2011, number 19, the limitation was imposed, and as per this limitation, if the granted loan amount is less than rupees 5 million, the bank cannot go Parate. Okay, bank cannot take action under 4 of 1990. If I explain further, now take a situation like this. The bank has granted a loan. Loan amount is 4 million. Loan amount is 4 million. And we have a mortgage. Land is mortgage for 4 million. Customer defaulted. The question is whether the bank can go Parate or bank can start Parate process under 4 of 1990. The answer is no. The bank cannot go Parate because as per the amendment number 1 of 2011 and number 19 of 2011, when the granted loan amount is below 5 million, the bank cannot start Parate process. Then what is the process that bank has to follow? Then court process. The bank has to file a court case and recover the money. So that is number 1, limitation number 1. Then the restriction number 2. The limitation was introduced by a case, a judgment given in this matter. Sumudu Sanjeeva Nanayakara versus HNB and others. As per this judgment, it is not only the granted loan amount. If the total outstanding is below 5 million, then the court has decided bank cannot go Parate. Bank cannot follow the Parate process. then in a situation like this, then the bank has to follow that regular action under Civil Procedure Code. We have to file action in courts. Then second, next limitation is called third-party mortgages. Third-party mortgages. So this is another limitation for the Parate Act, which was introduced by a famous case, famous judgment in a famous case, Chellaya Ramachandran versus HNB. This case that you have to remember, in this matter, it was decided if the mortgage property is a third party owned property, then the bank cannot auction such a property under Parati. Again, I will repeat, if the mortgage property belongs to a third party, that means it is not belongs to the borrower, it is owned by somebody else. Then in a situation like that, if the loan is default, the bank cannot auction the property under Parate. Instead of that, the bank has to file action in courts. Through courts only, it can be auctioned. So that was a decision given in Chellaya Ramachandran versus HNB case. So then Samathapala Jayawardena versus HNB, another matter that is very important here. It was decided in this case, if the property is mortgaged by, if the loan is given to a company and the property is owned by and mortgaged by one of the director of the company, if the director has been benefited, if you can show the director has got the benefit of the loan, in a situation like that, the bank can auction the property under Parati. Bank can auction the property under Parati. This is number 2. So there is another case, Mudita Pereira versus DFCC also, that you have to remember. So in these cases, it was decided if it is a third party mortgage property that is not subject to Parate, or bank cannot adopt Parate procedure to auction the property. In a situation like that, the bank has to file a regular action in courts, and through courts only the property can be auctioned. So that is Parate procedure. So if you have any questions, you can ask now from Parate process. Any questions? No questions. Okay, so then then I will go to the next topic. We have limited time, so we'll start the next topic. I'm going to discuss about the dormant accounts and abandoned properties. Right? So this is not a hard to understand. So therefore, I'll run through the slides very quickly. But if you have any question, of course, you can ask the question then and there. Dormant accounts. What is dormant account? Dormant accounts. Dormant accounts means account without any transaction for a long period of time. Any account without any transaction for a long period of time. It could be a savings account, it could be a current account, any account without any transaction for a long period of time. Then what happened? The bank classified this type of accounts as a dormant account. If there is an account for a without any transaction for a long period of time, bank has to classify that account as a dormant account. Once it is classified as a dormant account, the account holder cannot operate the account. He can't deposit or he can't take money unless bank change the dormant status. The time period to classify the account as a dormant account is vary from bank to bank. Another important point. Now the bank decide the time period. Some banks, it can be vary from the bank to bank. There can be a bank that they decide, okay, after 3 years we categorize account without a transaction as a dormant account. Or one bank, there can be a bank who decide if there are no transaction for 6 months, we categorize that as a as a dormant account. So there's no specific time period mentioned in law. It is as per the discretion of the bank can decide or bank can classify the account as a dormant account if there are no transaction for a long period. So bank to bank, it can be changed. Then what is the purpose of classifying this account as a dormant account? What is the purpose? Why do you want to classify? If the banks separate this account from the active account for the monitoring purpose, this is very important. You classify these accounts as dormant accounts because the bank has to monitor those accounts. So these dormant accounts or these fake accounts, sometimes without any transaction, people have accounts maintained for various reasons. It can be used, these accounts can be used for the purpose of laundering money, for money laundering purposes. So therefore, the bank has to be vigilant, and if there are no transaction in an account for a long period of time, the bank has to take a decision, and bank has to convert or bank has to categorize that account as a dormant account. So thereafter, the account holder cannot do any transaction. So you can see sometimes in money laundering transactions, it's a very famous thing that they open an account, no transaction for a long period of time. Then all of suddenly, after long period, the amount, some big amount comes to the account as a transfer or swift transfer or whatever. So money comes to the account. So that could be a money laundering transaction. So therefore, it is the duty of the bank to prevent money laundering and other illegal activities. The bank has to classify the account as a dormant account if there are no transaction for a long period of time. That is dormant account. Then what is abandoned properties? Abandoned properties. This with regard to the abandoned properties, section 72 of the Banking Act applies. You have to remember that. Abandoned properties, section 72 of the Banking Act. What is abandoned property? Any article or any deposit held with a licensed commercial bank unattended by the owner for 10 years. Right? As per section 72 of Banking Act, any article or any deposit held with the commercial bank unattended by the owner for 10 years from the date of deposit. If it is if it is a savings account, right? He deposit money to his account, no transaction, no deposit or anything afterwards for 10 years. Then that property or the account become an abandoned property. Become an abandoned property. Or from the date become payable. That means we say if it's a fixed deposit. Right? Customer put a fixed deposit for a year. Right? Then after 1 year, the maturity date comes. You have to pay. Auto renewal instruction is not given, and the customer won't come and collect the deposit. Unattended 10 years. So then it becomes an abandoned property. Right? If it is a safety locker facility, time period is given, safety locker facility is given for 1 year, time expired, customer unattended, it's not open, or he has not extended the period for another 10 years. In a situation like this, the property presumed as an abandoned property. Abandoned property means athara damu devula, right? So it is in a situation like this, if the property is not attended by the owner more than 10 years, it is considered as an abandoned property. Then in the banks, we have abandoned properties. We have abandoned properties. So what is the procedure that we have to follow with regard to the abandoned property? So since it is abandoned properties, can we take that property? Since no one is interested, can we take it? Can the bank say this is our property? Can the bank use that property? So what is the procedure that we have to follow? That is mentioned in this procedure under Banking Act. Abandoned properties, deposits and other monies held in the bank without any transaction over a period of 10 years, or safety deposit boxes with the bank where the owner has failed to respond within 3 years of the notice issued by the bank. If it is a deposit, unattended 10 years. If it is a safety locker or safety deposit boxes, unattended more than 10 years, then thereafter the bank has to send a notice. After sending the notice, no news or no response from the owner, another 3 years. So in a situation like this, it is considered as an abandoned property. So what is the procedure for the abandoned property? What do we do? As per section 73 of Banking Act, the bank has to make a report to the monetary board. So bank has to prepare a report on their abandoned properties. And that report has to be given to the monetary board of central bank. All the commercial banks, they have to prepare a report and give that report to the monetary board with regard to their abandoned properties. Once the report is given to the monetary board directs the bank, then the bank should transfer the money to the special account at the central bank. So central bank, they have a special account for these abandoned properties. Once the report is given to the monetary board can direct the bank or ask the bank to transfer that money, the abandoned property, to the central bank special account. Articles shall be reported to the monetary board and to the minister. So if there are articles, safety lockers, also unattended for more than 10 years and send notice and no news from the owner, then bank has to prepare a report on the articles, and that report should be given to the monetary board and also to the minister. Then 30 days from the report, the bank has to publish a notice in the newspaper. So then you send the notice to the central bank. After 30 days, the bank has to publish a newspaper notice with regard to the abandoned properties held in the bank. Then further, send notice. Bank has to send notice to the owners of the properties to the last known address, last given address to the bank. Send notice. Then afterwards, the owners or title holders can claim the money from the monetary board by providing proof for their ownership. If the notice is seen by the owners, then the owners can claim the money from the monetary board, because now the money has been transferred to the central bank. So therefore, the owners has to now claim the money from the monetary board by providing proof for their ownership. So then, if they prove that they are the owner, then the monetary board will release that money to the owners, or otherwise it will become the money of the government, state money. So that is the procedure that we have to follow with regard to the abandoned properties. Any questions from here? Abandoned properties and Dormant accounts? Okay, so then if you don't have questions, then I'll go to the next one. That is nomination. Nomination. What is nomination? Nomination is a facility that enables the deposit account holder or safe deposit locker holder to nominate an individual who can claim the proceeds of the deposit account or content of the safety deposit after the demise of the original depositor or locker holder. So, in other words, nomination means, if I explain to you with an example, we say I have an account in a bank, right? I have deposits in my account. If I die without nomination, what will happen? So, if it is a married person, account holder, if he is a married person, half of the properties, half of the money will go to the wife, widow, and the rest half will go to the children. Equally, it will go to the children. If he is not a married person, then the money will go to the parents and siblings. So that's how it happens if there is no nomination. But the account holder can give a nomination to the bank, appointing a nominee. Then after the death of the account holder, the money will go to that nominee as per the nomination. That is called nomination. That is called nomination. Right. So then, what is the law relates to the nomination? What is the law relates to the nomination? So nomination is mentioned, or the law related to nomination is set out in section 544 of the Civil Procedure Code. So you have to remember this, section 544 of Civil Procedure Code. As per section 544, any person over 16 years, not 18, any person over 16 years in Sri Lanka can nominate a person. So nomination can be done by any account holder over 16 years of age to receive the money or benefit upon his death for the following. For what that you can make a nomination? One, the money in accounts other than the current account. So the nomination can be made to any account other than the current account. For the current accounts, nomination cannot be done as per the law. Then number two, any shares in a registered company. If you have shares in a company, that you can nominate. If you are over 16 years of age, then you can nominate a person after the death of yours. That money will go to that nominee. Or any money deposited in a registered finance company. If you have deposits in a finance company, so that you can make a nomination. If you have a life insurance policy, you can make a nomination. Or any movable property deposited in a vault of the bank. If you have a vault facility, if you have deposits, movable properties, we say jewelries and other things in the safety locker, you can make a nomination. So after the death of that person, account holder, locker holder, the money and the items will go to the nominee, not to the legal heirs. So that is called nomination. How to make a nomination? Nomination can be done at the time of opening the account or later. So you can make a nomination at the time you're opening the account. Then and there you can give a nomination. Or later you can do that by giving instruction in writing to the bank. Make a nomination later. Nomination has to be done in writing. So nomination has to be in writing. You have to give written instructions to the bank nominating a nominee. No verbal nomination or no verbal instruction with regard to nomination is allowed. Nomination can be revoked by account holder later. So that means you can give a nomination today. Tomorrow you can cancel the nomination. You can cancel the nomination and you can give another nomination. You can't give two nominations. So, right? You have to cancel the previous nomination and you have to give a new nomination. So new nomination also that you have to give in writing. Revocation also has to be done in writing. So important thing, you have to give instructions in writing. You have to you cannot revoke the nomination, but that has to be done in writing. After revoking the previous nomination, you can give another nomination. That also has to be given in writing. So those are important points when you are making a nomination. Right. What is the effect of the nomination? What happens if you have given a nomination? So nominee is entitled to get the money deposited or benefit of the shares or insurance after the death of the account holder. So if there is a nomination, the nominee is entitled to the money or to the shares or to the insurance policy after the death of the account holder. So nomination become effective after the death of the account holder. That is very important. Then the nominee has to provide his identity to the bank or the company. How do you get, if you are a nominee, how do you get the money or how do you get the policy, insurance policy or whatever, if after the death of the account holder? What are the things that you have to prove? Only thing that you have to prove is your identity, right? If you are named as a nominee, that you have to show, you have to satisfy the bank that you are the person mentioned in the nomination form. So therefore, your identity that you have to prove. That's all that you have to prove. Then you are entitled to the money and the deposits and the items when in the safety locker. So if it is a company share, that you can get the shares or insurance policy and the insurance policy by proving your identity. Then number 3, the bank or the company has to pay the nominee and not to the legal heirs of the deceased customer or deceased account holder. So if there is a nomination, then the bank has to pay the money or whatever shares or insurance to the nominee, not to the legal heirs, right? Now you can see when there are nominations, you can see sometimes there are incidences that the legal heirs and the nominee both claim the money or the shares or whatever. So then the question is, who gets a priority? Who is entitled to get the money? The answer is very clear here. If there is a nomination, legal heirs won't get anything. Only the nominee will get the benefit of the account or of the safety locker or whatever. So then the nomination override the last will of the customer. Fourth point, very important. When there is a nomination, right? We'll discuss with an example, right? We say, I have an account. I have given a nomination. So as per the nomination, I say after my death, the money in this account should go to A. Then I write a last will also. As per the last will, the money in this account I have given to B. Now there are 2 documents. One is the nomination, the other one is the will. Contested 2 documents are there. As per the nomination, the money should go to A after my death. As per the will, the money should go to B after my death. So when there are 2 contested documents like this, what get the priority or what supersede? So answer is very clear. If there is a nomination, the nomination supersede or override the last will. So therefore, the money will be given to the nominee, not to the beneficiary of the last will. So therefore, remember the nomination override the last will of the customer. So there are some important points that you have to remember with regard to nomination. Number one, nomination will continue until it is cancelled. So once the nomination is given, if you don't cancel it, there's no expiry, it continues. The nomination supersede the last will. The number two, remember, if there are two contested documents, that is the nomination and the last will, nomination supersede the last will. Number three, the nomination can be done for all monies and funds in the bank account other than the monies in the current account. The monies covered by the nomination are monies in the fixed deposit, treasury bills, treasury bonds, savings account, money and articles in money and items lodged in the safety custody of the banks. Those are the things that we can get nominations. Other than the current account, we can get nomination for any other accounts. Then the fifth one, if it is a joint account, if one account holder is dies, the nomination automatically becomes invalid. Then the remaining account holder can, if he wish, he can make a new nomination. So this is called a survivorship concept. That means if it is a joint account, both, we say there are two people jointly maintain an account, and each one is entitled to the full amount in the account. If it is a joint account, we say A and B maintaining a joint account. We say 100,000 in the account. If I ask how much A owns and how much B owns, we can't say A owns 50,000 and B owns 50,000. Actually, as per the law, both A and B are entitled for the entire amount, that is for one lakh. Then, if it is a joint account, if one joint holder dies, what happened? The survivor will get the entire amount unless the other party has given instructions contrary. That means that he can show that money in the account is not belong to the other party. So then it is different. Otherwise, the survivor will get the entire money. So then what happened? During their lifetime, the both gives a nomination for the joint account. So after the death of one party, what happened? The nomination becomes null and void because the money will go to the other party. So other party, the survivor party, if he wish, he can write a new nomination. So those are the important points that you have to remember with regard to the nomination. With that, I wrap up today's lesson. If you have any questions from this topic, that is dormant account, abandoned properties, and nomination, you can ask those questions now. Any questions? Okay, if you don't have question, then we'll stop at this point. We'll have another revision class on next Saturday. The institution will inform you. The time is same, 1 o'clock to 3 o'clock next Saturday. So thank you for the participation. If you have any question, you can ask or even on the next day. Thank you very much.